SwayamPrabha. Digital India. Educated India.
Hello students, welcome to SwayamPrabha. This is a course on Procedural Law on Crimes, the Bharatiya Nagarik Suraksha Sanhita 2023. I am Professor Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. I, along with Dr. Saurabh Rana, an assistant professor at Faculty of Law, DU, would be delivering this course. Today, the topic of this session is maintenance of wives, children and parents. So students, let us first try and understand what is the concept of maintenance all about. Maintenance under law generally refers to the husband's obligation to financially support the wife during marriage and also on divorce or separation. Provisions for maintenance are given under the various personal laws as well as the Code of Criminal Procedure 1973. In matrimonial cases, the court has to ascertain the financial capacity or status of both the parties for fixing maintenance. In many developed countries, the law prescribes a comprehensive format of assets, income and expenditure to be filed by both the parties at the very threshold of matrimonial litigation. However, there is no provision of law in our country for directing the parties to disclose their assets, income and expenditure in a particular format. These were the observations by Supreme Court in the judgment Kusum Sharma versus Mahinder Kumar Sharma. See, ours is a country wherein majority of the people, they believe marriage to be a sacrament. And that is the reason prenuptial agreements are frowned upon. People consider prenuptial agreements as very materialistic and people are very scared of entering into these prenuptial agreements because they believe that maybe if we are in a way talking about such material aspects, then the relationship might be doomed. Little do they understand and appreciate, and in case there is a transparency amongst the parties, in case they both come with a fixed set of rights, obligations, responsibility in a relationship, then in case things turn sour, at least the exit point would be easier because the distribution of assets would be comparatively easier. In India, with the sole exception of Goa, where there is the concept of uniform civil code and the concept of matrimonial common property, in rest of the country, uniform civil code is still a distant dream, due to which we have concepts such as maintenance, because what happens after the marriage comes to an end, usually it is the women and children who find themselves at crossroads. In our patriarchal setup, where women they do not earn outside the homes, in such a situation they are dependent to a large extent for their sustenance on their husbands, and a lot depends upon the benevolence of the husband. So sometimes where the husband decides not to maintain, then in such cases the law has to step in and ascertain that women, they are not rendered destitute. See, in a case Badshah versus Urmila Badshah Godse and another, the Supreme Court of India explained the justification for granting maintenance by stating that maintenance is provided with the goal of strengthening the poor and attaining social justice or individual equality and dignity. So, it encapsulates societal ideals. Now, what is the justification behind award of maintenance? Maintenance is not merely a legal right. It is a part and parcel of basic human rights. For weaker sections, it is a problem in the sense that their very survival rests upon maintenance. The object of providing maintenance has been quoted by the Supreme Court in the judgment of Kusum Sharma versus Mohinder Kumar Sharma to be twofold. So, what are those two objects of providing maintenance? First is to prevent vagrancy that results from strained relations between the husband and wife. See what happens? In most of the cases, the property is in the husband's name, because it is the husband who is the main bread earner. In case of a fallout, the woman is thrown out of the matrimonial home. Most of the cases, parents are not willing to take back their separated daughters because they have already spent so much on her dowry and marriage and other things. Moreover, in our society, there is a stigma that is attached to a separated wife, due to which parents, they are also reluctant to take her back. In such a situation, what happens? There could be vagrancy for the woman when her relationship with her husband are strained. The second objective is to ensure that the indigent litigating spouse is not handicapped in defending or prosecuting the case due to want of money. See, on the breakdown of the marriage, it often so happens that the husband pays nothing for the support of his wife and children, and the children and the wife especially, she has to fall back upon her parents and relatives to fend for her immediate needs. Reasonableness too demands extension of such a relief in favor of the needy spouse. Had the parties not drifted away from one another, the spouse from whom support is sought would have supported the other spouse, entailing financial burden. Hence, it is but natural to make the husband bear the cost of maintaining his wife pending disposal of any dispute until some permanent relief in the form of maintenance or some other lump sum payment or maybe transfer of some property in her name. So, till the time some permanent relief is not given to her, it is the duty of the husband to bear the cost of maintaining the woman. So, what is the law relating to maintenance in India? In India, maintenance is a statutory right. It is something which the law has expressly declared, and we have various provisions in many statutes which deal with the concept of maintenance. Being a statutory right, in case there is an agreement to the contrary, see, maintenance is a statutory right. So, if there is any agreement to the contrary, in which there is an agreement between the parties that in the fallout no maintenance would be sought or anything like that, then what happens? Such kind of an agreement would be unsustainable in the eyes of law, because maintenance has already been guaranteed as a statutory right. So, maintenance, it might be granted throughout the course of the proceedings, that is what is known as maintenance pendente lite, or it might be granted after the completion of the proceedings when it is not a temporary measure, but it is a permanent measure. The right to claim maintenance under our laws, it is available to wives, children and parents, even husbands. See, those men who are unable to support themselves, where the wife is in a better position, when she is earning well, then in those cases even husbands are entitled to claim maintenance under specific personal laws, especially under the Hindu Marriage Act. So, what are the legal provisions under which maintenance can be claimed in India? Foremost, we have the most recent statute, which is the Protection of Women Against Domestic Violence Act of 2005, Section 20 of the law deals with that. Then we have the Hindu Marriage Act of the year 1955, in which we have Section 24 that deals with interim or temporary maintenance orders and also for expenses of proceedings. Then there is Section 25 which deals with permanent maintenance and alimony. Then there is the Hindu Adoption and Maintenance Act of 1956. Section 18 lays down provisions relating to maintenance of wife. Section 19 lays down provision relating to maintenance of widowed daughter-in-law. See, when we talk about provisions in procedural criminal law, it does not talk about daughter-in-law, it talks only about daughter. But in Hindu Adoption and Maintenance Act, there is a provision for maintenance of a widowed daughter-in-law who is incapable of maintaining herself independently. Then Section 20 of Hindu Adoptions and Maintenance Act deals with maintenance of children and aged or infirm parents, and Section 22 deals with maintenance of dependents. And then we have the secular provision in the form of Bharatiya Nagarik Suraksha Sanhita, which was earlier CRPC. Earlier the provision was Section 125 in Criminal Procedure Code of 1973. Now it is Section 144 under the Bharatiya Nagarik Suraksha Sanhita 2023. So let us now understand the statutory provision which is provided under our procedural criminal law. Chapter 10 of Bharatiya Nagarik Suraksha Sanhita deals with provisions relating to order for maintenance of wives, children and parents. See, the title of the chapter is order for maintenance. So this maintenance order, it can be made in favor of wives, children and parents. So this is a very small chapter comprising of sections 144, 145, 146 and 147, merely 4 sections, but this is a very important topic. So what does section 144, the old section 125 say? It says order for maintenance of wives, children and parents. The law reads, if any person having sufficient means neglects or refuses to maintain his wife, unable to maintain herself, or his legitimate or illegitimate child, whether married or not, unable to maintain itself. So foremost what we have to see is that there should be a person who should have sufficient means. See, an indigent, one who himself does not possess sufficient means, how can we expect such a person to support others? So here we are talking about a person of reasonable means, and when such a person either neglects or when such a person refuses to maintain. Now what are the categories of persons protected under this law? First is his wife unable to maintain herself. See, wife includes a divorced wife and a separated wife till the time she does not remarry. So what is to be seen is his wife who is unable to maintain herself. If the woman is independent, if she is earning, if she is capable of supporting herself, maintaining herself, then in such cases we need not invoke the law. This is talking about a wife who is unable to maintain herself or his legitimate or illegitimate child. See, the law is very progressive. It does not differentiate between children whether they are born out of the wedlock or whether they are born without wedlock. See, so a child, whether is legitimate or illegitimate, we've got progressive judgments in which the courts have mentioned that there is nothing such as legitimate or illegitimate child. All children are legitimate. What could be illegitimate could be the acts of parents, but the child has got nothing to do with it. So all children are legitimate children. The law says a man is supposed to maintain his legitimate or illegitimate child whether married or not. See, even unmarried children and married children also. What is the consideration? That the child should be unable to maintain itself. See, it is not talking about the responsibility to maintain only minor married daughters. It says any child, whether the child is married, whether the child is unmarried, but if the child is unable to maintain itself. So, the child would be, what is the definition of child? Ordinarily, a child is construed to be a person below 18 years of age. Then, his legitimate or illegitimate child not being a married daughter who has attained majority. So, you see, in cases of married daughters, whether she is the legitimate or the illegitimate child of the person, in case she is married, but she has attained majority. So, when such a child, even despite attaining majority, is unable to maintain itself, and what is the reason behind this inability? It could be reasons which could be physical or mental abnormality or injury. Okay. So, then legitimate or illegitimate child, even after attaining majority, the person is supposed to maintain that child, where the child is incapable of maintaining himself or herself. See, in cases of a married daughter, the responsibility to maintain the married daughter would be on the man who is now her husband, because she would be the wife of someone. So, she could be covered under subclause A of section 1, which says his wife unable to maintain herself. Here we are talking about children. So, child, whether it is a legitimate or illegitimate child who is unable to maintain itself, or even in case the child has attained majority, but where the child is not capable of maintaining itself, not able to fend for itself because of some physical or mental disability, then despite the child attaining age of majority, responsibility of the parent would still continue. And also his father or mother. So, you see, a person is responsible for maintaining parents also. The law says his father or mother unable to maintain himself or herself, a magistrate of the first class may, upon proof of such neglect or refusal, order such person to make a monthly allowance for the maintenance of his wife or such child, father or mother, at such monthly rate as such magistrate thinks fit, and to pay the same to such person as the magistrate may from time to time direct. So, the categories of persons who can be given maintenance under this secular criminal law are wife who is unable to maintain herself, children whether legitimate or illegitimate as long as they are minors. In case a child has attained majority, still if the child is unable to maintain itself, and the last category would be parents, either father or mother, whosoever is unable to maintain himself or herself. Then in such cases an order is to be made by the magistrate awarding maintenance, monthly maintenance amount to all the 4 categories of people. Provided that the magistrate may order the father of a female child referred to in clause B to make such allowance until she attains her majority, if the magistrate is satisfied that the husband of such female child, if married, is not possessed of sufficient means. So, you see, in case of married daughters also, if the magistrate is satisfied that the daughter, though she is married to another person and the primary responsibility rests on that other man, but if that other man is not possessed of sufficient means, whereas her father is possessed of sufficient means, then in such cases magistrate may order the father of a female married child also to provide maintenance to her. Provides it further that the magistrate may, during the pendency of the proceeding regarding monthly allowance for the maintenance under this subsection order, such a person to make a monthly allowance for the interim maintenance of his wife or such child, father or mother, and the expenses of such proceeding which the magistrate considers reasonable, and to pay the same to such person as the magistrate may from time to time direct. So, you see, even during the pendency of proceedings, interim maintenance can be provided under this subsection. Provided also that an application for monthly allowance for the interim maintenance and expenses of proceeding under the second proviso shall, as far as possible, be disposed of within 60 days from the date of service of notice of application to such person. See why this is? Because see, litigation, especially in such cases where the one of the parties is totally dependent on the money that they will receive from the other person in order to sustain itself. In such cases, it is absolutely necessary to have a specified timeline so that there can be a limit during which the person understands that I have to somehow manage for myself, and beyond that I would be getting maintenance by the intervention of the court. So, here the timeline that has been specified is within 60 days from the date of service of notice of the application to such person. Further, there is an explanation. For the purposes of this chapter, wife includes a woman who has been divorced by or has obtained a divorce from her husband and has not remarried. So, you see, wife would be a woman who is married to a man, a woman who is separated or divorced from that man, and even after that, till the time she does not remarry, she would be entitled to claim maintenance from her earlier husband. Irrespective of the fact that the man might have moved on, the man might have married another woman, but this would not negate his responsibility towards his previous wife who has still not married. Then, any such allowance for the maintenance or interim maintenance and expenses of proceeding shall be payable from the date of the order, or if so ordered, from the date of the application for maintenance or interim maintenance and expenses of proceedings as the case may be. If any person so ordered fails without sufficient cause to comply with the order, any such magistrate may, for every breach of the order, issue a warrant for levying the amount due in the manner provided for levying fines, and may sentence such person for the whole or any part of each month's allowance for the maintenance or the interim maintenance and expenses of proceeding as the case may be, remaining unpaid after the execution of the warrant, to imprisonment for a term which may extend to 1 month or until payment if sooner made. So, you see here what is required is that there has to be a compliance with the order. And suppose the person fails to comply with the order, and if he has sufficient reasons why he could not comply with the order within the given time frame, the court may still make a concession towards such person. But if the person fails to comply with the order and there is a lack of sufficient cause, I mean, what was the reason that you could not fulfill the order? Then in such cases, what would the magistrate do? For every breach of the order, the magistrate can issue a warrant for levying the amount due in the manner provided for levying fines. In addition to such fine, what will the magistrate do? He may sentence such person for the whole or any part of each month's allowance for the maintenance or the interim maintenance and expenses of proceeding as the case may be, remaining unpaid after the execution of warrant for an imprisonment for a term. And see, the imprisonment that is prescribed is, it could be either 1 month or it could extend till the time payment is made. So, the sooner he makes the payment, the sooner he would be able to effect his release. Otherwise, he would be in prison till the time the payment is not made. Provided that no warrant shall be issued for recovery of any amount due under this section unless, application be made to the court to levy such amount within a period of 1 year from the date on which it became due, and provided further that if such person offers to maintain his wife on condition of her living with him and she refuses to live with him, such magistrate may consider any grounds of refusal stated by her and may make an order under this section notwithstanding such offer, if he is satisfied that there is just ground for so doing. See what happens in most of the matrimonial cases. Whenever a woman demands maintenance, the husband counters it with an application for restitution of conjugal rights. Similarly, in cases of this Bharatiya Nagarik Suraksha Sanhita also, under this law also, whenever a woman wants to seek maintenance from her husband and she does not want to stay with the man, the reasons could be the man could be abusive, and abusive also in many ways, in multiple ways. See, there are so many kinds of domestic abuse that have been outlined in the Domestic Violence Act. There could be physical abuse, sexual abuse, emotional abuse, financial abuse, any kind of an abuse due to which the woman has withdrawn from her company, from his company, and the man offers to maintain her provided she comes back to his house, she takes care of him, she fulfills her conjugal obligations, whereas the woman, she does not want to stay with him. In such cases, if there are sufficient and reasonable grounds, the woman does not want to stay with this abusive man, then if the magistrate is satisfied that the woman is justified in going back and staying with that man, the woman is okay when she says that she does not want to stay with that man. So, the court will consider the grounds for refusal of the woman, and it is only when there are substantial reasons the court may order her maintenance. But in case the husband has made a genuine offer and the woman does not want to go back to him and she does not have any sufficient reasons also, in such cases the court may consider the other way round also. Explanation. If a husband has contracted marriage with another woman or keeps a mistress, it shall be considered to be just grounds for the wife's refusal to live with him. See, a man, he has contracted a second marriage and he says that, okay, you also come and stay here and I am going to maintain her. Or what happens in some cases? The man, he has not divorced his first wife, but he starts keeping a mistress. It is extremely shameful or derogatory for a wife to continue to stay in the same house along with the mistress of her husband. In such cases, if she does not want to stay with the man, refusal on these grounds that the man already has a mistress at home or he already has a second wife at home. So, on these grounds, the refusal of the woman to go back and stay with her husband would be a sufficiently reasonable ground as per the law. Then, no wife shall be entitled to receive an allowance for the maintenance or the interim maintenance and expenses of proceeding from her husband under this section if she is living in adultery, or if without any sufficient reason she refuses to live with her husband, or if they are living separately by mutual consent. So, you see, if they are living separately by mutual consent, or if she is living in adultery, or if she refuses to live with her husband without any sufficient reasons, then in such cases she would not be allowed to or entitled to receive an allowance for the maintenance or interim maintenance and expenses of proceedings. On proof that any wife in whose favour an order has been made under this section is living in adultery, or that without sufficient reason she refuses to live with her husband, or that they are living separately by mutual consent, the magistrate can cancel the order. Suppose an order has been made in favour of the wife who is staying separately from her husband. Later on, it is proven before the court that the woman is staying in adultery, or that the parties, they are staying separately by mutual consent, or that the woman is refusing to stay with her husband and there are no sufficient grounds for doing so. So, an order which was already passed, it may be subsequently cancelled also by the courts in such case. So, what is the objective behind section 125 CRPC, the old law, and now section 144 of BNSS? There is a judgment in this regard, Bhuvan Mohan Singh versus Meena and others, a 2014 judgment in which the Supreme Court has held that section 125 of CRPC was conceived to ameliorate the agony, anguish, financial suffering of a woman who left her matrimonial home for the reasons provided in the provision, so that some suitable arrangements can be made by the court and she can sustain herself and also her children if they are with her. The concept of sustenance does not necessarily mean to lead the life of an animal or feel like an unperson, to be thrown away from grace and roam for her basic maintenance somewhere else. She is entitled in law to lead a life in the same manner as she would have lived in the house of her husband. That is where the status and strata come into play, and that is where the obligations of the husband in case of a wife become a prominent one. In a proceeding of this nature, the husband cannot take subterfuges to deprive her of the benefit of living with dignity, regard being had to the solemn pledge at the time of marriage, and also in consonance with the statutory law that governs the field. It is obligatory on the husband to see that the wife does not become a destitute, a beggar. A situation is not to be maladroitly created whereunder she is compelled to resign to her fate and think of life dust unto dust. It is totally impermissible. In fact, see what the lordships have remarked, in fact it is the sacrosanct duty to render the financial support even if the husband is required to earn money with physical labor if he is able-bodied. There is no escape route unless there is an order from the court that the wife is not entitled to get maintenance from her husband on any legally permissible grounds. That is where she is capable of maintaining herself, or where she has withdrawn from the company of her husband without any reasonable cause, or where she is living in adultery. If it is none of the cases, then where the husband is not even earning, the courts have evolved the concept of an able-bodied man. See, if the man is able-bodied, if he has capacity to earn, he might not be well educated, he might not be technically qualified, but if he is able-bodied, he is supposed to do manual labor, he is supposed to do anything that he can in order to support himself and in order to support his wife. See, that is the extent of the sacrosanct duty that has been imposed on the man by the law. Then there was another judgment, that what would happen. See, we know there are multiple laws under which women, they can claim maintenance from the husband. What would happen in case there is an overlapping jurisdiction? The woman, if she is claiming maintenance from more than one place, she is claiming maintenance under her personal law also, she might be claiming maintenance under the DV Act also, then she also wants to seek maintenance under the secular law, which is the section 144 of the BNSS. Then in such cases, what is the criteria to be seen? In this regard, certain guidelines were laid down by the Supreme Court in the case of Rajneesh versus Neha. The objective behind these guidelines was to overcome the issue of overlapping jurisdiction and to avoid conflicting orders being passed in different proceedings. Now, why we needed these guidelines was because it is necessary to ensure uniformity in the practice that is followed by family courts, district courts and magisterial courts throughout the country. So, what are the guidelines? First, where successive claims for maintenance are made by a party under different statutes, the court would consider an adjustment or set-off of the amount awarded in the previous proceedings while determining whether any further amount is to be awarded in the subsequent proceedings. So, you see, you have already received maintenance under one proceedings, maybe there was a lump sum amount. So, when we are making a subsequent order, the amount that you have received earlier would be set off, because what the courts arrive at is the finality or the totality of sum that should be payable to a woman. So, in case that has already been awarded to her under some other proceedings, so that amount would be set off to the extent that was awarded under those particular proceedings. It is made mandatory for the applicant to disclose the previous proceedings and the orders passed therein in the subsequent proceedings. See, you cannot take the courts for a ride. You should come to the court with clean hands. So, now it has been mandated that in subsequent proceedings you have to necessarily disclose what you have received in any earlier proceedings. Then, if the order passed in previous proceedings requires any modification or variation, it would be required to done in the same proceeding. Coming to payment of interim maintenance, the affidavit of disclosure of assets and liabilities annexed as enclosures as may be applicable shall be filed by both parties in all maintenance proceedings, including pending proceedings before the concerned family court, district court, magistrates court, as the case may be throughout the country. So, you see, whenever you are seeking maintenance, both the parties, they have to file an affidavit of disclosure of the assets and liabilities. What all do you have? What are the burdens? What are your assets? What are your liabilities? All that has to be honestly disclosed, and that is why there is this condition of affidavit, so that the person would not lie, so that only truth would be revealed in such affidavits, so that the court has a comprehensive idea of what all parties, what all assets and liabilities either of the parties entails, and then accordingly the court can arrive at a reasonable and just conclusion that what is the amount, if any, that is to be awarded to the woman. Now, what is the criteria for determining the quantum of maintenance? So, for determining the quantum of maintenance payable to an applicant, the court shall take into account the criteria, the following criteria. First would be the party status. Here we are talking about both the parties. What is the status of the husband? What is the status of the woman? What was the lifestyle that the woman was accustomed to while she was the wife of that woman, while she was the wife of that man? So, that status, what is the capacity of the man to pay? What is his status? So, all that would be kept in mind while deciding. Then the applicant's needs. What are there any peculiar needs or wants of the woman, of the applicant? Is she suffering from any other medical condition or such, due to which she might be needing some more money? Does she need more support? Or whatever her needs are, on the basis of that, the court has to arrive at a proper decision. Then the respondent's income and property. See, the woman, she might be requiring a lot of money, but till the time the respondent is not in a position to pay, if he is not earning well, if he does not have any property in his means, in short, if he is not possessed of reasonable means, then accordingly the quantum of maintenance would be decided. The claimant's liabilities and financial responsibilities, that would also have to be seen, that if a woman, she is claiming maintenance for herself, or whether she has to support her children or any other liabilities that she might be having. So, that also has to be considered. There is a possibility that the husband might have constructed a house and he might have purchased a loan in the woman's name. Now, that is the woman's liability. She has to repay those installments while she is not earning. So, while deciding the quantum of maintenance, the courts would have to bear in mind what are the liabilities of that woman. Accordingly, they have to arrive at an amount. Then the parties' age and employment status. These are also important considerations, whether they are young, whether they are of an employable age, whether they are old, what is the status of their employment, are they employed, are they retired, are they never employed. So, all that would have to be seen. Then the parties' residential arrangements. Does the man have his own house? Is he living in a rented property? What is the status of residential arrangement regarding the woman? What is the locality that she has been staying in so far? What is the locality where she would like to continue to stay, or which would be according to her status and the status of her husband? What would be the rentals or the cost of property in that particular area? So, all this and more would have to be considered. Then the parties' minors' children's maintenance. So, if the kids are minors, their schooling, taking care of them, their nutritional needs, and all these things would have to be borne in mind before arriving at an amount. Then illness or disability. Any of the parties suffering from any kind of an illness, or any of the parties if they are suffering from any kind of a disability. So, what are the related expenditures? What are the expenditures on the medical treatment or the support staff or any other thing? That all would have to be borne in mind. So, you see the list that has been drawn by the courts. The aforesaid factors are, however, not exhaustive. See, these are merely illustrative. There could be any more criteria also for deciding the amount of maintenance. So, these are not exhaustive, and the concerned court may exercise its discretion to consider any other factors which may be necessary or of relevance in the facts and circumstances of a case. So, you see, there cannot be an objective yardstick. There is a lot of subjectivity involved depending upon the facts and circumstances of each and every case. Then, what is the date from which maintenance is to be awarded? Maintenance in all cases will be awarded from the date of filing the application for maintenance. See, not from the date of disposal of the application. The maintenance would be payable from the date of filing of the application. So, even if the order is made, say, after 2 months, the balance of the previous 2 months would be paid, and then thereafter the monthly installments would be paid. Then coming to the enforcement or execution of orders for maintenance. So, an order or decree of maintenance may be enforced under section 28A of the Hindu Marriage Act, section 26 of the Domestic Violence Act, and section 128 of the Criminal Procedure Code as may be applicable. Now, it is section 144 of the BNSS. The order of maintenance may be enforced as a money decree of a civil court as per the provisions of the Civil Procedure Code, more particularly sections 51, 55, 58 and 60 read with order 21. Now, whenever we talk about the concept of maintenance under section 144 of the BNSS, which was earlier section 125 of CRPC, the most significant leading judgment on this case is Muhammad Ahmad Khan versus Shah Banu Begum. This is an old case. Judgment came about in the year 1985, but this is a landmark judgment. This is also the judgment in which the Supreme Court had remarked and emphasized upon the significance of uniform civil code in our country, especially for protecting the rights of women. See, I will just tell you the facts of this case. What had happened? This woman, Shah Banu, she married Muhammad Ahmad Khan in 1932. Now, she stayed with this man for a very long time. She had 5 children with him. She had 3 daughters and 2 sons. In 1978, see, so many years after her marriage, she was thrown out of the matrimonial home along with her children. When the husband stopped supporting her financially, she moved a petition before an Indore court and she sought maintenance under section 125 of the Criminal Procedure Code 1973. What happened? when she filed this petition, the husband immediately pronounced talaq on his wife in the talaqul biddat form, which is the triple irrevocable declaration of divorce. So, what the husband did? He pronounced talaq on her in the triple irrevocable form, and then what he said before the court was that we are governed by the Muslim law. In India, we have two sets of laws that govern people. One is the secular law, which applies to all of us irrespective of the religion that we profess. The other is the set of personal laws. Now, personal laws govern us in matters of marriage, divorce, adoption, maintenance, guardianship, inheritance and succession. Now, these are personal matters in which what would be the law would be determined as per the practices and tenets of the individual religion that people profess, and that is why we have separate set of laws for Hindus, Muslims, Parsis, Christians, say in matters of marriage and divorce. So, what the husband did in this case, he tried to evade the law by pronouncing divorce on his wife, and then he said that as per my religion, I am supposed to maintain my divorced wife only during the period of iddah. So, iddah is the period of 3 months from the date of declaration of divorce, and this is ordinarily 3 months, but it extends up to 9 months also in case the woman is pregnant. So, this would extend till the time the woman delivers the child or aborts the child, whichever is earlier. So, in this case, because Shah Bano Begum was an old woman at that time, what he did, he paid her the monthly installment as was mandated by his religious beliefs for a period of 3 months, and after that he stopped and he contested the wife's claims in the court by saying that, see, I have already done my bit. I have done what my religion enjoins me to do, and as per our practices, I have already paid the maintenance to my wife during the iddah period. But the court did not listen to him, and he was directed by the magistrate to pay maintenance of ₹20 per month to his wife, to the respondent, that is Shah Bano Begum. The High Court increased this amount to ₹179 per month. Aggrieved by this increase in amount of maintenance, the husband, Muhammad Ahmad Khan, challenged this before the Supreme Court. In 1985, a 5-judge Supreme Court bench upheld the Madhya Pradesh High Court's ruling and also directed Khan to pay an additional ₹10,000 to his wife Shah Bano Begum. The same bench, it went ahead and slammed the All India Muslim Personal Law Board for siding with Bano's husband in the case. The bench said, it is also a matter of great regret that Article 44 of our Constitution has remained a dead letter. Students, Article 44 of our Constitution enjoins a goal, that is Uniform Civil Code. So, what the Lordships have remarked, that Article 44 of our Constitution has remained a dead letter. There is no evidence of any official for framing a common civil code for the country. Now, in this case, the courts, they also remarked that, see, ordinarily we have the personal law and the secular law, but whenever there is a conflict between the personal law and the secular law of the land, the secular law shall prevail. And saying so, Shah Bano was awarded maintenance under the then section 125 of the Criminal Procedure Code. Thereafter, let us talk about some more judgments. Now, how is section 144 of the BNSS to be interpreted? So, we have judgments wherein the courts have ruled that the term wife, as it appears under the law, it includes divorced wife for the purposes of this provision. In the case of Shah Bano versus Imran Khan, this is a 2010 judgment of the Supreme Court of India. The court held that a divorced Muslim woman would be entitled to claim maintenance from her divorced husband so long as she does not remarry. See, here again that Shah Bano Begum's case has been reiterated, that although under the personal law, the husband is supposed to maintain his wife during the period of idda only, but whenever there is a conflict, the secular law has to be prevail, and accordingly what does the court say? A Muslim woman who is divorced would also be entitled to claim maintenance from her divorced husband as long as she does not remarry. If she is unable to maintain herself, she is entitled to take recourse of section 125 of CRPC. This is a 2010 judgment which was enacted so many years after the legislature had hastily enacted a law titled Muslim Women Protection of Rights on Divorce Act 1986. This was a ploy to defeat the Supreme Court judgment in Shahbano Begum's case. But then there for a long time we had many conflicting decisions, that is whether that Muslim Women Protection of Rights on Divorce Act would prevail or whether women would also be entitled to claim maintenance under section 125 of the CRPC, and also at the same time what would be the correct interpretation of the provisions of Muslim Women Protection of Rights on Divorce Act. So finally in 2001 in Daniel Latifi versus Union of India, Justice Rajendra Babu had set the record straight by stating expressly that the future of a wife as envisaged in that law, it is not restricted to the period of idda. The future of the life has to be calculated keeping in mind her age, how long she is supposed to stay unmarried, independent, what is the amount of expenditure, what is the quality of life that is she is accustomed to. So keeping in mind that the husband has to make a reasonable and fair provision for the future of his wife, and the payment of that reasonable and fair provision, which would be a lump sum amount, keeping in mind all the consideration as to the future of the wife, the payment has to be made to the woman during the idda period. So that was such a beautiful judgment, and thereafter you see in 2010 when we get the Shahbano versus Imran Khan, the court again says that the woman, even a Muslim divorced wife, is entitled to take recourse of section 125 of CRPC. So you see these remedies, these are not mutually exclusive in nature. Coming to maintenance to child. Now under the BNSS, there is provision for maintenance to wife, maintenance to child, and also maintenance to parents. So in case of Neha Tyagi versus Lieutenant Colonel Deepak Tyagi, 2021, the Supreme Court concluded that the respondent's duty and responsibility to maintain his son until he reaches the age of majority cannot be relieved. A child should not be made to suffer because of a disagreement between husband and wife. The father's duty and responsibility for child's maintenance remain until the child reaches the age of majority. Next, coming to maintenance of daughter-in-law. While considering the instant review petition filed under section 19, subsection 4 of Family Court Act 1984, challenging the validity of the magistrate's order granting maintenance to the petitioner's daughter-in-law and her children under section 125 of CRPC, the Karnataka High Court, upon closely reading 125 of CRPC, held that a daughter-in-law cannot lay a claim against her parents-in-law. Provisions of law envisage that a wife can lay a claim for maintenance, but not a daughter-in-law. This was the judgment of Supreme Court in Abdul Khadir versus Taslim Jamela Agadi. This is a very recent 2024 judgment of Karnataka High Court. Coming to maintenance of parents. Section 125(1)(d) of the code has imposed a liability on both the son and the daughter to maintain their father or mother who is unable to maintain himself or herself. This is a judgment in the case of Vijaya Manohar Arbat versus Kashi Rao Rajaram Savai. This is a 1987 judgment of the Supreme Court of India. See, a daughter after her marriage does not cease to be a daughter of the father or mother. If it is not so, parents having no son but only daughters and unable to maintain themselves would go destitute if the daughters, even though they have sufficient means, refuse to maintain their parents. See, the object of section 125 CRPC is to provide a summary remedy to save dependents from destitution and vagrancy, and thus to serve a social purpose. There cannot be no doubt that it is the moral obligation of a son or a daughter to maintain his or her parents. It is not desirable that even though a son or daughter has sufficient means, his or her parents would starve. Apart from any law, the Indian society casts a duty on children of a person to maintain their parents. If they are not in a position to maintain themselves, it is also their duty to look after their parents when they become old and infirm. Now, procedure has been laid down under section 145, and proceedings under 144 may be taken against any person in any district where he is residing, or where he or his wife resided, or where he last resided with his wife, as the case may be with the mother of the illegitimate child, or where his father or mother resides. So, all evidence, they have to be taken in the presence of the person against whom an order of payment of maintenance is proposed to be made. Additionally, the court may also order costs. Alteration in allowance is also permitted. Suppose there are certain conditions that have changed, like if the woman, she has remarried, or in such cases the court can cancel the order, and then there can be an alteration also in the allowance if there is a change in the situation or condition of either of the parties. Then section 147 talks about enforcement of order of maintenance. See, what is the nature of proceedings? Proceedings under this provision are not criminal proceedings, although this is a criminal law statute. An application made under section 144 is not a complaint. Thus, the persons that are proceeded against, they are not accused persons. Proceedings under this provision, they are summary in nature, and therefore, magistrate or family court need not go into minute details of the matrimonial dispute to ascertain who was wrong. So, students, that would be all relating to law of maintenance as provided under the Bharatiya Nagarik Suraksha Sanhita. Thank you.